Assalamualaikum everyone. I'm Nurrani, would like to present on the first case study, the Corfu Channel case. This case was the first case handled by the International Court of Justice, and the step involved was UK and Albania. So the background is, UK bring this case to the Security Council of UN when two warships of British was destroyed by the explosions of mine at the Corfu Channel. The Security Council recommended the UK and Albania to refer this case to the ICJ. So, UK filed an application to the court claiming that Albania had violated the international law because of the failure to warn the warship of British regarding the existence of the mines. In fact, Albania have the exclusive power to watch over the Corfu Channel, and this is the legal obligation of Albania. In response to this application, Albania proceeds to file a preliminary objection that claimed UK permitted a unilateral application. So, on January 1948, ICJ proceeds to the Albanian preliminary objection by considering time limit for the UK to observe on the objection. The next point is the legal obligations of UK. Albania claimed UK have the legal responsibility for sending troops through the Corfu Channel without the consent of the Albanian government, and claimed that UK violated Albania's sovereignty. Besides, Albania also claimed that UK intended to have an aggression towards Albania. After all, ICJ decided that UK did not violate the international law because the Corfu Channel was freely used after October 1945. Last but not least, ICJ determined that Albania should have international obligation toward the explosions since it was an elementary consideration of humanity. The merits of holding and reasoning of this case is relevant to the International Humanitarian Law (IHL) because ICJ revealed that the elementary consideration of humanity in the Corfu Channel case are a legal principle.
Assalamualaikum everyone, my name is Siti Norliza and I will be moving on to the next point in Corfu Channel case, which is assessment of compensation. So during the public hearing on November 17, 1949, the United Kingdom had written its final submission for amount of compensation that were separated into three remunerations, which are the loss of sonorous, damage of volage, and the casualties as well as the injuries of naval personnel sums up to 843,947 pounds. Upon discussing about the effectiveness of actions and laws applied, the special agreement that was signed by both Albania and the UK played an important role to ensure both parties to pay the duty of compensation and satisfaction. There were two concerning terms arising from this case, which were to be decided under international law. Firstly, whether Albania was responsible for the explosion that occurred in Albania waters, or whether the United Kingdom had violated the sovereignty of Albania through the minesweeping operations without getting their prior consent. As for the duty to pay for compensation, the special agreement had ensured that Albanian government was obliged under the international law to compensate the loss of human life and damages of British warships, and also the application of international humanitarian law had shown its relevancy in dealing with this issue without involving any form of armed conflicts. As for the second term, the United Kingdom did not obtain the authorization from the Albanian government to carry out the minesweeping operation, so Albanian government was rightful to demand a satisfactory result. In conclusion, the Corfu Channel as the first case to be brought into ICJ was significant in examining the effectiveness of relevant laws applied for dispute settlement, and it is suggested that while Corfu Channel is considered as an international passage, it is the duty for Albania to make sure that its territorial sea harmless by any action, and so that the ships of other states may not be damaged. And should the United Kingdom maintain that their minesweeping operation as an act of self-defense, they should not pass through the territorial water without the prior consent of Albania. So by signing the special agreement, Albania and the UK had entered into diplomatic discussion, and with that, effectiveness of applicable laws and actions subjected to this issue, both countries successfully performed the duty of compensation and satisfactory by concluding the case on December 15, 1949.
I will now present our second case study entitled The North Korea Abduction Issue. North Korea has been conducting illegal criminal abduction targeting foreign nationals from many countries, notably South Korea, Japan, few Asian countries, and Europe states since 1946. After the late Kim Il-sung made national remarks to bring the Southern Chosen intelligentsia to the North to solve the country's shortage of intelligentsia, his three Kim predecessors leaders have effectively implementing kidnapping foreign policy to accomplish the state's interests. This abduct operations is not merely conducted, rather it was authorized at the highest level with webs of different assists including the state's army, navy, intelligence agents, and special forces. North Korea abduction program has undergone three phases over the years, that is, number 1, the strategic phase, number 2, the cohort expansion phase, and number 3, defensive phase, which changes based on the situations in the international order that decides the blueprints of the regime's foreign policy. This highly competent, fully backed up abduction spree served both as strategic and propaganda purpose in the state's impasse with its neighboring countries. As of 2018, a sum of 516 South Korean abductees remains detained in the North Korea, whereas 487 people were taken away since 1945 until 1977. The Japanese nationals that were seized from public beaches and city streets were taken abruptly to serve the regime as a language instructor, aspired spies, and another cultural talent carrier. North Korea's abduction issues for propaganda while securing order in the international sphere forecast the regime to pull out abduction as a foreign policy tool. This baffling movement not only violated human rights, but also increasing awareness for policymakers to uphold the law and acts execute notion to prevent the issues from sickening. Dialogue mechanism, travel restrictions, cutting diplomatic ties, and implementing sanctions are few and some of the solutions to be suggested and engaged by the international organizations and community to punish these gruesome actions from keep on happening in the future.
Assalamualaikum warahmatullahi wabarakatuh. I am Nurhafizah binti Arman, and I will continue the presentation with violation of international law in North Korea abduction issue. Article 3 of the Universal Declaration of Human Rights stated that everyone has the right to life, liberty, security, and of person. Article 9 of the Universal Declaration of Human Rights stated that no one should be subjected to arbitrary arrest, detention, or exile. And Article 966 stated that everyone has the rights to liberty and security of person. No one should be subjected to arbitrary arrest or detention. When abduction happened, it is clearly a violation to these three provisions where the victim's right for freedom, enjoying life, and feeling safe is being denied. On 1969, Korean YS-11 was hijacked by North Korea and abducted all of the passengers. North Korea had violated the Hague Hijacking Convention, where it is stated that a state is prohibited to hijack an aircraft. In Article 11 of Tokyo Convention 1963, where the provision mentioned that an attempt to hijack of aircraft is an act of quasi-piracy committed against the community of nations. Most of the abductions by North Korean agents were happened at the victim states. This shows that North Korea has trespassed the territory of other states, resulted in a violation of Article 2 Clause 4 of the Charter of the United Nations, where it is mentioned about the prohibitions to use any threat of force on any members and to always suspect the sovereignty and territorial of other states. Next, I will talk about the actions taken by the international community. Japan was the aggressive countries that keep putting pressure on North Korean government. In 1991 and 2002, after the first Japan DPRK summit meeting and the signing of Japan DPRK Pyongyang Declaration, Kim Jong-il finally admitted the crime and apologized to Japan. Japan raises the abduction issues until today in any international meeting. The bilateral and multilateral meetings and summits, such as Japan-Russia Summit Meeting December 2016, Japan-United States Summit February 2017, Japan-United States Foreign Ministers Meeting in March 2017, Japan-US Korea Trilateral Foreign Minister Meeting April 2017, the G7 Ishima Summit May 2016, and General Debate Session of United Nations General Assembly September 2016, where Japan raises the abductions issues and wish for understandings and cooperation from those countries involved to solve the abductions issues. The United Nations, Japan and European Union co-sponsoring almost 22 resolutions regarding the situations of human rights in North Korea, and as a result, a commission of inquiry was established in March 23 to investigate on the abductions issues. In December 2014, more countries supported the resolution on the situation of human rights in the PRK Nation General Assembly, resulted to an urge by countries to United Nations Court of Criminal. In May 2019, the Human Rights Council Working Group on Enforced or Involuntary Disappearance suggested more concrete actions to bring the victims home, and the suggestion was gained support by 88 countries.
Assalamualaikum, my name is Siti Hajar and I am going to talk about the effectiveness of action taken by international community. Exigency by the international community had been done for years. However, after all the exigencies received by North Korea, the country firmly said that the abduction issue has already been settled. Japan continues to bring up the abduction issue in all kinds of forums to gain support from various countries involved. Prime Minister of Japan, Shinzo Abe, continues to attempt a meeting with the North Korea leader Kim Jong-un to resolve the fate of abductees. Japan urged that it could not normalize diplomatic relations with North Korea until the issue is resolved. But North Korea shows no sign of interest in the summit with Japan anytime soon. In spite of the analysis, Abe has underlined his eagerness to push ahead with Japan's own way to deal with taking care of North Korea. Abe promised to tackle the snatching issue during his Japanese discourse in Washington in the early 2013. Abe has likewise demonstrated the chance of culmination meeting among him and Kim Jong-un, and Japanese government sources have alluded to the chance of further reciprocal talks between the two. Abe has clarified that settling this issue is a need and that Japan has its own planned autonomous of Washington and Seoul about North Korea. In this vein, Japan's one-sided approach may remove trilateral strategy coordination with the US and South Korea. There is no uncertainty that the adoption issue is remembered for the remarkable issues of concern. During the review through the United Nations Universal Periodic Review process, the North Korean government expressively denied all reported abuse cases, claiming that allegations are based on distorted facts or manufactured, or that negative assessment of the human rights situation in North Korea are based on misinformation manufactured by those who betrayed their country. The international community must acknowledge its obligation to ensure that the individuals of the Democratic People's Republic of Korea from violation against humankind in light of the fact that the government of the Democratic People's Republic of Korea has plainly neglected to do as such. Specifically, this obligation must be acknowledged in the light of the pretended by the worldwide network and by the incredible powers specifically in the division of the Korean landmass and as a result of the ascertained inheritance of the Korean War. Thank you. That's all for our group.